Good afternoon. I am Lauren Rose Hoffland, and you're watching League TV, a service of the League of Women Voters of Sheboygan County. The League of Women Voters is a nonpartisan, grassroots political organization established in 1920 that advocates for the informed and active participation in government. Our members are women and men who work to improve our systems of government and impact public policies through education and advocacy. The League neither supports nor opposes candidates for office at any level of government. Today, we are interviewing Judge Jeff Davis, the incumbent candidate for the District 2 Wisconsin Court of Appeals. On September 4th, 2019, Judge Davis was appointed to the Wisconsin Court of Appeals by Governor Tony Evers to fill the vacancy created by the departure of Judge Brian Hagedorn, who was elected to the Wisconsin Supreme Court. Before we begin, we're going to offer up a short course, very short, in this very important branch of our judicial system. The Court of Appeals is the state's intermediate appellate court and is composed of 16 judges from 4 districts, headquartered in Milwaukee, Waukesha, Wausau, and Madison. The primary function of the Court of Appeals is to correct errors that may have occurred at the circuit court level. Any citizen may appeal a final judgment or order of a circuit court. Those opinions which are published by the Court of Appeals are binding precedent until overruled by the Wisconsin Supreme Court. The court generally sits in 3-judge panels to decide the merits of an appeal. Several categories of cases, however, are decided by a single judge. District 2 encompasses most of the southeastern quadrant of the state and includes the counties of Calumet, Fond du Lac, Green Lake, Kenosha, Manitowoc, Ozaukee, Racine, Sheboygan, Walworth, Washington, Waukesha, and Winnebago. Judge Davis, before we begin the interview, we want to thank you for agreeing to meet with us today and also for investing your time and resources in running for office. In the conversation before we started the interview, you shared an analogy with me that is a great illustration of the function of the appellate court. Will you share it with the rest of us, please?
Sure. Thanks, Lauren. And hello, everyone. The analogy that I use with respect to what our court does goes back to something that Chief Justice John Roberts alluded to years ago. And he compared a judge to a baseball umpire, calling balls and strikes without bias, or a referee, what have you. And if you go with that analogy, and I think it is kind of appropriate, our court, the Court of Appeals, is really like the replay booth. We will take those few decisions by a trial judge or a baseball umpire, with the analogy, that are challenged by one of the parties to the contest, and we're off in a darkened room reviewing the decision. We look at it from all different angles. We're able to study it, drill down and see if there was error made, and that, and then make a determination whether the trial court got it right or not. So that's whereas a trial judge will be made that's like a referee, we making hundreds of decisions during the course of a trial, or we would only look at a very few of those issues that come up to us in the Court of Appeals, and so it gives us an opportunity to really determine whether or not legal error was made.
Thank you. That does clarify it. I appreciate that. So, Judge Davis, please tell us a little bit about your background, particularly your legal and judicial experience.
Sure. So I've been on the bench for a year and a half, and in the course of that time, I've written a number of opinions, some of which have been published, many of which have not, and they've covered all different areas of law, civil law, insurance law, some criminal law cases involving mental commitment issues, things of that nature. But before that, I practiced law for 32 years in private practice. I was at the law firm of Quarles and Brady in Milwaukee. Began in 1987. And when I I was in our litigation group from the beginning. As it turns out, my first case went to the Wisconsin Supreme Court, which really got me interested in appellate law. And I tried cases for clients over the years, but also had a parallel practice with appellate work, and had a number of practices sort of lended themselves to appellate work. Got to know a lot of the appellate judges over the years, as well as some of the Supreme Court justices, and expressed an interest in at some point joining their ranks if the opportunity came along. And I was encouraged to do that by a lot of my friends who were judges and justices, with the message that we need more people like me coming from the private ranks, because there is sort of a dearth of business and civil law expertise on the bench. A lot of times, there'll be district attorneys and those types that will want to become judges, but not as many lawyers from the private bar. So, in 2019, the opportunity came along as a point in my career where I felt like I could make that leap, and applied for the position with the governor, and was appointed.
Great segue. You were appointed to your first term. What are the specific aspects of this judicial position that moved you to run for a second term?
Well, I really love the work that I'm doing, and people sometimes, at least in the legal profession, think of the Court of Appeals as the judges sort of living in a cave. that we're all a bunch of law nerds, and to some degree, they're right. I wouldn't trade the 32 years I had at Quarles for anything. I love working with clients, the legal strategies that we developed, trying cases, but I also always had another side of my personality, which was a real love for the law and the analytical challenges that it presents. I've always loved to write, and in the Court of Appeals, we do a lot of reading and writing. And I was at a point in my career where I felt like I could sort of indulge that passion. And the other thing is that I reached a point in my private practice where I didn't feel like there was that much left for me to accomplish. And I was sort of looking, for some new horizons to conquer, where I could learn new areas of the law. I didn't have as much of a criminal practice at Quarles, for example, and I learned something new every day on this job, and I'm going to keep learning. And that's part of what I think any judge should view it that way, that there's always things to learn. I was talking to Justice Annette Ziegler the other day, and she said, yep, she's still learning every day on this job. And that's one of the things I really enjoy, is learning new things. And you learn something new with every brief that you read on this job.
So, Judge Davis, what is your judicial philosophy, and how does that philosophy influence your decision making?
My philosophy is, in some ways, I think kind of simple. It's to be very faithful to the law, whether I agree with it or not, and very faithful to the record, the factual record that comes before us, and make sure I have a thorough understanding of what the actual facts are that come before us. Our cases are decided on a given set of facts. We don't try cases. We don't decide who was telling the truth or not. But we are giving a detailed record of what happened in the court below, and then asked to apply the law, or asked to determine whether the law was correctly applied to that record. And I think my philosophy is to be very scrupulous in applying that law. I understand my role is not to make the law, but to simply apply the law as written to the record below. But I also understand that it's not necessarily something where you can just sort of stamp, what the law is to a decision and move on to the next case. It takes judgment calls, because there are shades of gray in this world. Reasonable minds can disagree as to what the law actually means, or what some passage in testimony means. And in doing that, in making those judgment calls, my philosophy is to be intellectually honest, thoughtful, and very thorough, and to bring, frankly, my 32 years of experience into the mix, because I think a lot of this is about common sense. and determining what the law is does require, thinking about terms and thinking about the issue in terms of what makes sense.
Thank you. So there has been much written in mainstream and social media about the courts ruling in clearly conservative or liberal ways. What are your thoughts on that? And how, as a judge, do you keep your personal biases from influencing your decisions?
Well, in the first, with respect to the second part of your question, absolutely. And it's hard, every judge needs to strive to do that. And that's not easy because as human beings, we all do have personal biases. We just do. And part of what what I've learned as a judge, and again, it's something where I think you have to continuously learn it and strive to do it, is to ignore those biases when you get a given case. And there'll be, whether it's because I know who the lawyers are, or I might have had some relationship with them when I was in private practice, or whether I have a particular point of view about an issue, you can't let that seep into your decision making. And it is something that can be acquired, and that I have acquired it. So it's really interesting to now experience that, and to see how you can look at these cases very objectively. And that's got to be that really has to be our goal. As far as a conservative versus liberal philosophy, and sometimes I think that's a bit overblown. I'll tell you, for example, that I fully agree with Justice Gorsuch. One of the things that he said in the course of his confirmation hearing was that he has two rules for his law clerks. Rule number one is don't make stuff up. Rule number two is when someone tells you that you're being unfair, go back to rule number one. I don't make stuff up. I apply the law as best I can, being as objective as I can. And where that lands me in the conservative versus liberal spectrum, I have no idea, but that's what I do.
Thank you. What is the most significant challenge facing the Wisconsin Court of Appeals, and how can that challenge be addressed?
Well, I think the challenge is to prevent as much as possible the politicization of these races, quite frankly. I think it's really important that these races be viewed as the nonpartisan nature that they're intended to be. Judges, and frankly, I've never been a member of a political party or politically active. And I've always thought that made the judiciary a pretty good spot for someone like me. And I still think that. I think that judges, as much as possible, we're sort of a different beast in the system of government. And that's by design. And that comes from our founding fathers. You need look no further than Federalist Paper number 78, written by Alexander Hamilton on the judiciary, when he spells out how important it is that judges be above politics and independent. And I think that is a challenge more and more as our current environment has gotten more politicized in the other branches of government. It's more important than ever that we keep the judiciary away from those forces.
Under what circumstances should the state constitution be interpreted differently from an identically worded provision in the federal constitution? Or are there any circumstances under which that should occur?
There could. I mean, that's a matter. Frankly, that's a great question, and it kind of goes to the heart of what federalism is, which is that the states do have the ability to sort of marshal their own affairs, as long as they're not in violation of a federal law that would bring into play something called preemption, or a constitutional provision which acts the same way. There's authority that says that states are, if they have their own constitutions, and I don't want to get all law geeky here, but there are circumstances in which states can deviate from the federal interpretation of an identically worded statute in some instances where they can't. And I subscribe to that. It's not an issue that typically is decided at the level of our court, because that's really going to be more of a lawmaking function at the Wisconsin Supreme Court. And it's also, I think the rules where that can occur are also fairly well settled, but it can happen. And it's a matter of states having, a fair amount of autonomy over their own affairs. That's the underlying philosophy.
Thank you.
Sure.
If an attorney displays a clearly inappropriate bias in the courtroom, such as calling a female witness by her first name and her male counterpart by his surname, what, if anything, should a judge do?
Well, that's not a situation that I will ever confront, because we don't have trials or anything like that. With the rare exception that we do have oral arguments on occasion, and I couldn't imagine that really happening in that situation. But if it did, I think in any given case, that's one where the judge should correct that attorney. And it may not be anything that's necessarily intentional in any given case. I don't know, but one way or the other, I think it would be, the judge would need to call the lawyers aside and may, make a comment to that effect.
Last question, describe the ideal judge.
Well, I like to think that the ideal judge would display the attributes that I've described previously that I strive for. The ideal judge would be independent and above bias, and basically be very thoughtful and experienced, and have a mix of real world experience, but also judicial experience, and the respect of the community, as well as the judge's fellow colleagues, and a personality or a temperament, if you will, that is that's even-handed. And so I think what a big part of what we do in terms of serving the public is not only judging cases that come before us and meting out justice, but also making people feel like they received justice and that they got their day in court. And I think part of what gives people that perception is the demeanor of the judge, or in our case, frankly, the demeanor of the opinions we write, because most people don't get in front of us. But I do try to be, in my opinions, I try to make it clear that we have addressed the issues that the parties raised, and we've addressed them thoroughly, and we've addressed them clearly. And so, my output, if you will, to the public are my written opinions, and I try to make them user-friendly and clear, because I think that's really the way we can best serve the public.
Thank you so much for taking the time to interview with us today, Judge Davis. The League of Women Voters strongly encourages all who are eligible to vote in the upcoming general election, which is on April 6th. If you are not registered to vote, you may sign up easily on myvote.wi.gov, or you may contact your municipal clerk for more information. Other LeagueTV interviews may be found on our website, including our conversations with candidates for the Sheboygan Mayor, Sheboygan Aldermanic District 2, and the Sheboygan Area School District Board of Education. Judge Davis, we wish you the best in your campaign and in the elections. And again, thank you for joining us.
Sure. Well, thank you, Lauren. I really appreciate the opportunity.